Gentlelady from California.
I move to strike the last word.
The gentlelady is yielded 5 minutes.
Thank you, Mr. Chairman. It's interesting that we get non-Californians who are somehow experts in our laws in California. I've lived with these laws my whole life and want to point out several very important distinctions between H.R. 5 and the MICRA law that was passed in California. MICRA was a law that was passed in California in 1975. And there are some very clear differences between the two. As Ms. Waters mentioned, H.R. 5 applies damage caps in all health care lawsuits, including cases against drug companies, nursing homes, and insurance companies and HMOs. MICRA, the California law, only applied to malpractice cases against a doctor or a hospital. Punitive damages, which are reserved for only the most egregious medical malpractice, those kinds of punitive damages are meant to deter the dangerous conduct that people are engaging in and to deter them from continuing to do that in the future. But MICRA didn't cap punitive damages. They're still available, but H.R. 5, in stark contrast, gets rid of punitive damages. H.R. 5 gives a total immunity from punitive damages to drug and device manufacturers if their products have been approved by the FDA or are generally recognized as safe and effective. MICRA didn't have that kind of sweeping immunity for the drug industry. H.R. 5 caps non-economic damages at $250,000 in the aggregate, no matter how many parties have been damaged by medical malpractice, even when an injury results in the loss of a marital relationship. California law recognizes a separate claim for loss of consortium so that a spouse can bring a claim if their loved one is injured or dies, and MICRA doesn't limit those kinds of claims. H.R. 5 does. H.R. 5 is a very radical piece of legislation, and I keep hearing that somehow it's modeled after California's law and that it's resulted in this magical reduction in medical malpractice premiums. But the fact of the matter is medical premiums in California, malpractice premiums in California, didn't go down after MICRA was passed, didn't go down after MICRA was implemented. They only went down after Prop 103 in California was passed, and that proposition limited what insurance companies could charge for medical malpractice premiums. So it wasn't MICRA that created these magical savings for doctors, it was insurance reform. There are unprecedented legal protections for the insurance industry in H.R. 5, but there's no guarantee that any future savings that these insurance companies have will be passed on to doctors in the form of lower premiums or their patients in terms of the cost of health care. So I think it's very important that if people are going to try to make the analogy that this is somehow in any way, shape, or form comparable to what has happened in California, they at least be educated on the facts of what has happened in California, because H.R. 5 is vastly different. It's far more radical. It has all these sweeping immunities. And we're talking about $250,000 caps, which, again, Mr. Nadler correctly points out, were implemented in the 70s and have not kept pace with inflation or the cost of living. So to somehow say that you have been grievously injured, or in some cases people have died because of medical malpractice, and that because we want to save money, we're only going to allow people to claim up to $250,000 is really an insult to those people who have been injured or who have been killed. And so this is just a bad bill all the way around. I urge my colleagues to support Ms. Waters' amendment and to vote against final passage of this bill. And I will yield to my colleague from California.